Plaintiff Stephen Harmon is suing his former employers for services rendered and slander. Stephen says he edited pornographic DVDs that the defendant starred in, but he has yet to be paid for his work. Defendants James Crippen and adult film star Christopher Martin say the plaintiff is lying and trying to overcharge them, and they're countersuing for breach of contract.
All right, Steve Harmon is suing his former employer for services rendered and for slander, and the defendants James Crippen and Christopher Martin are countersuing their former employee for breach of contract. Steve, I'll start with you.
Thank you. I began working with Chris in 2006 on a website and later some video production. Chris is a well-known gay porn star who wanted to begin producing his own DVDs. Well-known? Yeah, he's been in 30 or 40 titles. You're probably not familiar with his work, so I'll skip that.
Okay. All right, so you meet.
Right.
I just went blank after that. Hit me, Jen.
I began working on his website and then video
working on his
production.
website.
Yeah. Paul is his business partner in the company.
Who's
James Paul.
James Paul. Yeah. Okay.
In July of 2007, I signed a video services contract with them for video collection and video editing and DVD authoring and distribution.
What does that mean? What exactly did you contract to do for them?
To run the video cameras, do the video editing.
And you mean like to video the...
To create DVDs.
In other words, to like a camera, watching them.
Right. To videotape it.
Okay, so you're taking pictures and stuff.
Right.
Okay.
Exactly.
All right. Okay, so what happened then?
The first production was released in September of 2007. It was called Bearing It All, and that was successful. And between April and June of 2008, we began work on the second and third productions, Going Solo and Bareback Casting Couch. I sent the masters to our distributor in July of this year, and the payment for the work that I did on those two DVDs was withheld for a couple of months. And the reason that I was given at that time was the distributor hadn't paid them. And all
right, so here's the deal. You sign a contract, which I'd like to see if you have a copy of it.
Yes.
You have a contract that you're going to videotape the acts.
Yes.
And you're going to create a DVD, and they're going to send it out to the distributor. Is that correct, Paul?
Yes.
All right. So let's see this contract. All right, Videographic Services Agreement between Chris, who's Chris Neal Enterprises?
We are.
So that's the name of your company, Chris Neal Enterprises, but you're James Paul and you're Christopher. Okay.
Correct.
Looks like a pretty standard contract dated 7/5/07. Let's look at this contract, show this to the defendants, make sure we're talking about the same contract. Go ahead, Steve. Why are we here? They're not paying you? Because they say they haven't gotten money from the distributors.
That's what they said for a while, but then when the money was forthcoming from the distributor, I didn't receive it then. That's when the suit was filed.
Okay.
Some things happened in the meantime, but I received a letter terminating my services with them on September 16th that was signed by Chris, and it was really a shock to me because I didn't know there was a problem with my work, and I called Chris, and at that time, he told me that he hadn't signed this letter and he wasn't working with him.
Let's see it. Who signed the letter? Paul, did you sign the letter?
Yes, I did.
Why did you, all right. I have received in the past few weeks a number of calls on a new invoice and reviewing the invoice. I find it interesting. It's substantially higher than the last one you sent, considering I've not given you any new projects. Your work was marginal at best. You do not follow directions. All right. Now, did you sign this, Chris, this letter?
It was signed by Paul with my consent.
But you signed, whose name, Paul?
I signed Chris's name.
Why? Why are you signing his name? Why are you telling him to sign your name?
I wasn't, I live in North Carolina. Paul lives in Palm Springs, California.
Yeah, but are you two partners?
Yes.
That's correct. I have a contract.
Did they tell you they were partners, Steve?
Yes.
Okay. Is it true? I mean,
when I called Chris to ask him about it, he said that he didn't know anything about the letter and that I was, as far as he was concerned, I was continuing to work with them.
Is that true?
No, Your Honor.
All right, let's assume that you do porn videos so you don't know about contract law. I'll give you that one.
Yeah.
But when he says he calls you and you said no, that Chris didn't, or that Paul didn't have your permission to fire him, what did you say to him?
I said that I hadn't written the letter.
Okay, I'm going to leave that in the middle. I don't know whose side that one's on. Let me ask you this, the two of you. You're getting invoices from Steve. You're not paying them. All right. Now, what you're saying is that the invoices are far more expensive than you expected them to be?
Correct.
Okay.
Far more.
All right. And do you respond in writing to them?
I continued to send the invoices, and Chris continued to say that when they came from the distributor, I would get it. At that time, I made plans with Chris to travel to San Francisco when he was going to be there to film another scene for a movie. And I traveled to San Francisco intending to meet with him and film a scene and receive some of the payment. And when I got there, I met with him in a restaurant, and Paul spoke of the letter, and Chris agreed with him, and I realized that what was going on.
All right. So in the meantime, you not only did a DVD, and then you expended money to meet them to do another video.
Yes.
How do you expect him to do a video, gentlemen, and travel to meet you to do another video and not pay the guy?
Well, Your Honor, I disagree with what he's saying. And
Tell me how.
well, if I may give you a little more background.
Go ahead.
First off, I met Chris 3 years ago in Chicago in Palmer House. We subsequently decided to become life partners. And Chris is a major porn star. But he was tired of making all this money for other companies. Mm-hmm. So he approached me about the possibility of developing a partnership so that he could make money from all the, from the excess of the DVDs. And I have a copy of the agreement here. And
Okay.
this was done, dated on June of 2007.
This is the agreement, your partnership agreement between the two of you.
That's correct.
All right, June of 2007, and then you enter into a contract with Steve Harmon in July of 2007.
That's correct.
All right, good, fine.
So what happened is that we decided, because Chris was known under the name of Chris Neal, and that we branded it under that with the company. So we opened the company called Chris Neal Entertainment with the subsidiaries of Chris Neal Media, which is our film company. Again, it's not that big, Your Honor, but and then we also have a line of clothing that we also have designed or done. So those are the three elements we have. We were all new to this. I'm new to it. I'm the CFO, and basically I would take care of all the financial matters. And the problem here, Your Honor, is the fact that I have here a copy of a statement shows the invoices. I also have the copies of the invoices and also payments we've made to Mr. Harmon that he failed to tell you about. And I would like to.
She hasn't asked me that. I have an Excel spreadsheet that shows all of that and
All right.
the invoices.
Let's see. So they did pay you
There
some
were
money,
payments
Steve.
made, but just not in some total.
All right. Total amount paid to Mr. Harmon, $2,562. Is that correct?
No.
Okay.
This shows all the same MoneyGrams, but it also shows you all my charges over that time, and these are the invoices that correspond to that.
How much
spreadsheet.
money did you receive from them?
$25.50 by my calculation.
Good. That's about where they are. Good. We're in good shape here. $25.50
But the
according to
total
your...
load was $5,600 for a difference of $3,050.
You say they owe you $5,600 based on how many hours that you put in?
That's itemized.
Good. Let me see that. Thank you.
You're
All
all
right. Hold on a second. Steve, I want you to finish your case right now.
All right. After traveling to San Francisco and realizing what was going on, at that point, I also began hearing from people in Palm Springs that mutual friends that wouldn't return my calls because things that they had been hearing from Paul about
Like what?
our relationship. I wasn't welcome anywhere near the building that he owned and things like that.
So your friends are telling you that Paul is bad-mouthing you.
Yes.
And are they saying specifically what he's saying about you?
That I wasn't allowed in the building where a couple of adult film stars lived that he owned, and that was it. And they would stop returning my calls. I intended to be doing some work with them, and I wasn't able to then.
Do you have any statements to
No,
corroborate
no.
this, Steve?
No.
You know, defamation, which is, slander, if it's verbal, as opposed to libel, which is in writing, is something for which you can recover if you can show that as a businessman or as anyone that you suffered financial damages as a result of a statement made by, in this case, the defendants, which wasn't true. Were you allowed in their building?
No, I just heard that was what was being said. So.
Did you say he couldn't come to your building?
No, Your Honor.
Okay. Were you allowed in the building?
I never attempted to.
So we don't know if it's true or not true. So you're not going to recover.
Right, no.
If you had a statement and if you could show that someone didn't hire you, I mean, I would be happy to recognize that as a serious cause of action. When you're in business, you don't damage someone else's reputation because that's how they make their living. Let's face it, it's word of mouth. Why are we not paying them, gentlemen? The additional $3,000 that he says you owe him.
Because that's not the amount that we owe him.
What do you think you owe him?
Okay. Your Honor, what's happening here is that for some reason he fabricates a lot of information that if we question, he takes personally. And I would basically question him on these amounts, and he would basically get annoyed and defensive. I have a good example here. He indicates here on June 4th that he was doing a bareback casting couch DVD cover. He never did that. We have here a statement from our distributor stating that they clearly did the front and back cover. I have copies, Your Honor. I don't know if you'd like to see them
Sure.
of the
Love
two.
to see it. What did you do? Talk to me, Steve. Did you do work on the cover for bareback casting?
Yes, I
couch?
did, and they ended up not using the cover that I designed for them because the distributor decided to. The distributor wanted something a little more racy than the one I had designed, so they used a different cover than the one that I designed.
Oh.
But I would like to also. Paul said that when he spoke with me that I was defensive. The truth is that Paul and I haven't spoken in about a year since Chris sent me an email saying that he didn't want Paul speaking to me anymore because Paul tends to annoy people and ruin relationships.
Do you deny that he did work on the cover of Bareback Casting Couch, even though it wasn't what you ultimately selected?
I've never seen it, Your Honor.
Okay. You're countersuing for breach of contract?
Right.
The contract reads, the manner in which the services are to be performed and the specific hours to be worked by Steve Harmon shall be determined by Steve Harmon. And the fee of $25 an hour for video collection and $50 for video editing shall be payable upon delivery of the video content. You deliver the video content? What'd you deliver?
2 master DVDs that were then replicated for distribution.
Basically, this case is about whether or not the defendant is liable to the plaintiff for breach of contract and slander, and whether the plaintiff is liable for breach of contract. They both say that the other party breached the contract. I've already ruled on the defamation, that you did not prove your case and present a prima facie case as to whether or not there's defamation, and so I am dismissing that out of hand. Now, it's undisputed that the two of you entered into a contract where the plaintiff was to perform work for the two of you in this new partnership that you had developed. He claims that he hasn't been compensated for work performed. You say that the work, according to this letter to the plaintiff in September, it was marginal at best. You don't provide direction or provide us with a quality final product. Therefore, we're terminating the agreement. This is September 16th of 2008. Now, what's curious is that the bills are for this $2,500 and the additional $3,050 are monies that you believe are owing to you before you received this letter, before September 16th of 2008.
Yes.
Now, defendant admits that they owe the plaintiff some wages for work performed. In fact, they paid him for some.
Correct.
But they are saying that the plaintiff has overstated what he has done. Pursuant to the contract, and I have spoken to some of the editing people on this show as to whether or not 88 hours is an inordinate amount of time for the kind of video that they're talking about. I've been told it is not. The bottom line is that this contract is so clear that it is a subjective determination by the plaintiff, and you did not actually let him know that there was a problem until after he incurred those expenses, that as far as this court is concerned, the contract is so airtight that the plaintiff wins $3,050, so be it. Thank you.